Welcome back to Living 757. Did you know that if you're found to be even just 1% at fault in an accident in Virginia, you might not get any financial help in a personal injury claim?
I did not know that.
Yeah, this is really scary stuff. It's called contributory negligence, and Virginia is one of the few states with this harsh rule. Here to break it down for us, because we need all the help we can get, is attorney John Paulson with Huffman Huffman Brothers in Law. Thank you so much for joining us.
Hey, John.
Contributory negligence.
Right.
What does that mean?
I know, it is harsh. You kind of hit it on the head with that statement. Like you said, we're one of a few states, 4 in the country, have this law. Funnily enough, two of the other 3 are Maryland and North Carolina. So,
go figure.
So this Mid-Atlantic area is kind of harsh when it comes to this kind of law. But what it basically says is a law in Virginia that it says if one person contributes to an accident in any way, shape, or form, 1%, they're barred from any recovery, believe it or not. So a person's injured as a result of an accident, you look at the accident, and you think, oh man, this guy's definitely at fault for this accident. But if certain things are found under the law, and a fact finder such as a judge or a jury says, nope, you contributed to the accident, you get to collect 0.
Okay. So you're telling me you're driving down the road, you go through a green light.
Sure.
Somebody T-bones you.
Right.
There's a chance that if you're found 1% at fault for that accident, that you won't get anything towards your medical bills even?
Correct. And that's, like you said, that's a tough law. And it's a law that we deal with on an everyday basis.
I bet.
Insurance companies, insurance defense attorneys, they love it. I mean, most of their arguments are based, we call it contrib, around this contributory negligence. But your scenario right there is kind of extreme, obviously. There's very few scenarios where you're driving through a green light and you get T-boned that you're going to be found to be contributory negligence. So a lot of times it doesn't come into play, but often it does.
This seems so unfair. I mean, this whole 1% thing, first of all, I don't even know how they can determine the 1%.
Right.
And is there anything people can do to protect themselves from contributory negligence?
Sure. The number one thing, obviously, is to be a safe driver. Do not drive distracted a little bit. I've been here, a few months ago, we talked about distracted driving. Do not be on your cell phone, not be distracted while you're driving. But where we see it come into play, and you got to remember insurance companies they have a certain way of wanting to make sure that if they don't have to pay on a claim, they won't.
Exactly.
So where that comes into play with this,
Yes.
well, where it comes into with this contributory negligence is a person's just in an accident. They're speaking to a police officer, and they tell them what happened.
Oh boy.
You got to be careful in those scenarios. Obviously, you need to talk to the police officer and tell them what happened. But later on down the road, when you call an insurance company to file a claim, they often want to make a recorded statement. And that's where we definitely say it's vitally important to talk to an attorney before you make that statement.
So you can teach us what not to say on that phone
well,
call.
I can't tell you what not to say, but I can tell you what they're looking for, certainly.
It's so true, because I've been in that situation before where the other insurance company would call me and try to get me to say something.
Sure.
I don't like that.
Right, of course.
So what do we say? We just say, no, let me call my attorney. Let me call Huffman Huffman.
Oftentimes, I would recommend that you have an attorney before making those calls or before answering those calls.
I can't hear you.
Sorry, click.
Well, you can do that. You can do that, and then call one of us, and we can be on the phone with you during those recorded statements often. So
now, could you give us a quick few scenarios that we can tell you, or we can try to tell you, if there's contributory negligence or not?
Yes. Let's do some easy ones first.
Okay.
Okay. You're driving down the 264, you're going 55 miles an hour, and you slam on your brakes and you get rear-ended. Did you contribute to the accident?
Yes.
I should say you slam on your brakes for no reason. There's nothing in front of you.
Yes.
Okay.
Yes.
Yeah,
That's
absolutely.
an easy one, right?
Yeah.
Okay. Let's make it a little bit harder. Let's say you're driving in your neighborhood and the speed limit's 25, and you tell the police officer that you're going 35 miles an hour, and somebody pulls out from a stop sign. Did you contribute to that accident?
Yes.
Yeah. There's definite case law that says if you're going over the speed limit, you potentially give up your right of way. So you have to be
Interesting.
careful.
Yeah.
I'll give you the most extreme example that we hear quite a bit, because there's a principle in Virginia called the last clear chance law, doctrine, last clear chance doctrine. And what it basically says is that if you have the last clear chance to avoid a collision and you don't, then you are potentially contributory negligent.
Wow.
So where this comes into play is you're at a signal, traffic signal, and you're going straight, right? And your light turns green, and let's say the car is coming in the opposite direction, making a left in front of you, has one of those flashy yellow arrows, right? You proceed, and then you're hit by that vehicle. If you tell the insurance company, which is something we hear all the time, they came out of nowhere, I never saw it,
Oh boy.
you're potentially negligent.
Absolutely. We can learn so much
Yeah.
from you, but we are out of time. So
Yes.
tell us quickly how viewers can get a hold of you.
The information is up on the screen already.
There you
John, thank you so much for joining us.
Okay.